You're listening to Civic Media. You can tune into any of our live shows on any radio station across the state with the Civic Media app. Find us in your phone's app store and listen anytime, anywhere.
Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Jim Santel, and yes, indeed, this is once again Amicus, a law review. This is, as you know well, our weekly weekend review, our analysis, our discussion of those major news stories in the areas of law and government, the aspiration for justice, and yes, indeed, the rule of law in Wisconsin, throughout the United States of America, and on the face of this planet. As always, I am honored, I am delighted to have you join me this weekend for our examination of all of those issues and more. As always, we're tackling some of the most significant issues, and there is a lot. There is a lot from just this past week. And before we begin to talk about those things in the areas of justice and courts and government, we are mindful as we gather this weekend about the horrific events in Washington, D.C. just this past Wednesday. Passenger jet and a Black Hawk helicopter colliding in midair Wednesday evening, crashing into the Potomac River near Reagan National Airport. The president confirming late this past week that there were no survivors. The plane, an American Eagle flight, regional jetliner, was carrying some 60 passengers, 4 crew members on a flight from Wichita, Kansas. Also, 3 soldiers aboard that U.S. Army Sikorsky H-60, Defense Department official told CBS News. Obviously, the investigation continues, the pursuit of the truth, what happened there. And we are mindful as we gather this weekend, as always, about the horrific deaths, the pain and the suffering suffered not only by the families, but the larger community that has now lost many people in this tragic incident there in Washington, D.C., and we are thoughtful about their lives, the lives lost, the things that could have been, and also about the things that will be with their family members as they continue to live their lives in the wake of this horrific tragedy. Also note, of course, that this is a matter for government attention. The National Transportation Safety Board, the Department of Transportation, our secretary, others necessarily focused on, again, what happened. What are the facts of the situation, the circumstances that caused this horrific crash immediately adjacent to the Potomac River? How did this happen? And indeed, there will be an awful lot of attention to government, the mechanisms whereby government oversees and regulates to the good, even in situations like this, our air, our traffic, our transportation systems generally. Undeniably, there will also be those times when this issue and others like it will be brought into the courts of America. We will continue to monitor all of that as we go forward in America in the wake of this latest and recent, after many, many years of no air crashes in America, most recent crash in our nation's history. We do live in a time when the Department of Justice continues to animate much of our attention here in the United States of America, and that includes some things that we ended in our last program, our last broadcast last weekend, and that is focusing upon this issue of pardons. Again, normally in the normal process, the regular process in the Department of Justice, this unit, this office called the Office of the Pardon Attorney, not established constitutionally, but under the rubric of providing some regularity, some common sense, some process for those people who would seek to invoke the president's authority under the Constitution to grant pardons, to grant clemency. This is the process. This is the office that reviews those applications, or at least has reviewed them in the past, to provide, again, some consistency, and ultimately based upon some fundamental standards about the timing of these applications, about the merits of them, the things that commend them or don't commend them to the president, making recommendations to the White House about what should or should not happen on these various applications. We know that in the recent days of the Trump administration that Donald Trump pardoned approximately 1,500, almost 1,600 January 6 rioters and granted clemency to many others, including Proud Boys and others who were responsible for organizing and supervising the events of January 6th. In the wake of that, some commentary in our last broadcast about the kind of pardons that these are, not contemplated by the Constitution, that as we understand it, as James Madison wrote this particular provision, as we understand it in the Federalist Papers, an opportunity for the president to express mercy, to grant these kinds of special considerations to people who warrant it, not to excuse and not to forgive, and certainly not to overlook the horrific, violent behaviors of this particular group of pardon recipients. We talked a lot about that in our last broadcast. It is significant to note that even in the wake of the granting of these pardons to these great many recipients by our current president just in recent days, at least 12 people pardoned by Donald Trump in his first term and, yes, recently in his second term, including 2 just last week, have since been rearrested by the police or otherwise are running afoul of law enforcement. All of that we know because of reporting about who these people are and what has happened in the wake of these pardons. What we know, of course, is that Donald Trump pardoned 238 people in his first term and did indeed pardon about 1,500, almost 1,600 Capitol rioters following his reelection and his retaking the White House just recently. At least 10 people pardoned between 2016 and 2021. 2 people pardoned last week were charged again on new crimes after their presidential release from prison. A third Capitol rioter remains on the run from police due to a prior warrant. Now, what do we know about these people? Well, 2 Capitol rioters, again, have had run-ins with the police, one of them fatal, which again is tragedy, absolute human tragedy, within a week after being pardoned by the president. His name is Matthew Huddle. He was fatally shot by an officer after allegedly resisting arrest at a traffic stop in Indiana. According to some local police there, Huddle was apparently in possession of a firearm, and during the stop, that firearm and others used, unclear whether he attempted to use it during the arrest, but plainly he was shot as a result of his encounter with police at that time. The second Capitol rioter to be arrested is Daniel Ball. He was taken into custody for a federal gun charge from 2023, shortly after his release from prison, despite being pardoned over his actions on January 6, where Ball allegedly did what? Well, he threw an explosive into the Capitol, causing hearing loss among police officers and also other injuries, which lasted for months. Ball still had a criminal record for domestic violence, battery by strangulation in 2017, and resisting law enforcement with violence and battery in 2021, meaning that his possession of a .22 caliber rifle and ammunition put him in violation of federal gun laws. And there's a third Capitol rioter who's currently on the run from Texas police due to a pre-existing warrant from 2016. Andrew Taake, Taake, is wanted on charges of online solicitation of a minor. Despite the Harris County District Attorney asking the federal prison to keep Taake in custody, he was released and now is on the run from authorities. Those 3 recently in the wake of the pardons granted to them by the president of the United States of America. We will continue to monitor, of course, all those kinds of things related to pardons in America, the impact of them, and the diminution of the meaning of the pardon in our Constitution and in our national life. Also this weekend on Amicus, a law review, a deeper dive into all kinds of things happening inside the Department of Justice, things with respect to the Civil Rights Division, the cases that are being shut down or certainly suspended. We're going to talk about some movements of attorneys previously within the Department of Justice with great authority into other areas where their expertise is no longer useful or no longer directly applicable. We'll talk about the movements inside a thing called the Honors Program and the cancellation of Honors Program attorneys for employment in the Department of Justice. We'll talk about the firing of some prosecutors by the White House, by the Department of Justice. Those prosecutors, where were they? They were inside, of course, the team that Jack Smith had assembled to prosecute the now present president for both insurrection related to January 6th, an attempt to overthrow the results of the 2020 election, but also that Mar-a-Lago documents case. Those attorneys were fired just recently. We'll talk recently about the decision by the present leadership of the Department of Justice to issue memorandums to all of the sitting United States attorneys, many of them in acting positions, to investigate and prosecute local and state law enforcement if they do not comply. If they do not comply with the mandates of the White House in connection with immigration policies. We'll talk about some reporting also that Eric Adams, the embattled New York mayor, charged in the federal system for corruption for his conduct in office and his other conduct out of office. Discussions apparently going on inside the Department of Justice about whether or not to dismiss that case against him. We'll talk about some of the connections between Eric Adams and our current president. Then necessarily we're going to go down the street. We're going to go down to the Supreme Court once again and update what's been going on there in the United States Supreme Court, talking about some of the oral arguments on deck by the Department of Justice in recent weeks, including cases involving things like excessive force by the police. We'll talk about how the oral argument in that particular case played out in recent times. We'll talk about the decision of the Supreme Court upholding a money laundering ruling, a money laundering policy, a practice, a statute. It's going to affect, again, the ways in which prosecutors address money laundering and some other cases as well. Give you a sense of how many cases there are pending, what's going to be going on in the month of February as well. And then, of course, we also will update you on a couple of other things related to justice and the law, rule of law. Rudy Giuliani recently settling his major case involving that defamation of his against two Georgia workers. Millions of dollars settled recently to bring him out from under the pressure, the contempt of the court. We'll talk about that case. And also the recent sentencing. Yes, that's right. A former Senator Bob Menendez, 11 years in prison based upon his corruption as alleged and proven in a federal court in Manhattan. All of that and more coming up here on Amicus, a Law Review, as we talk about these things that happen in the midst of an administration that continues to surprise and distress and dismay many Americans for the ways in which they're issuing executive orders, rescinding them, all of that also a part of the rule of law. Why? Because decisions and executive orders by the president, depending upon their status and their legal status as well, are also matters for the law, matters for all of us to be attentive to here on the broadcast stations of Civic Media and Amicus, a Law Review. Stay with us.
You're listening to Civic Media. Stay up to date on the latest news and information for your local community and Wisconsin by signing up for our free email newsletter. Visit civicmedia.us/email to get started.
This is Amicus, a Law Review. My name is Jim Santel. For this hour and next hour here on this first weekend broadcast of the new month, doing a deeper dive into things we have not talked about with great particularity recently. That is the Department of Justice, things going on inside the Department of Justice, even as America anticipates the arrival of a new Attorney General, her name Pam Bondi, the arrival likely of a new director of the FBI, his name Kash Patel, having gone recently through those processes, the advise and consent process, which is required of these appointees through our Constitution. Meanwhile, the Department of Justice still going on, still operating, and in many ways doing things that, yes, are part of an interim and a transfer kind of process inside the Department of Justice, but things that nonetheless affect the ways in which we understand the law in America, even in this transitional period as we change administrations. Let's talk about a number of those, 4 or 5, maybe even 6 of them that are going on right now inside the U.S. Department of Justice. Main Justice on 9th and Constitution there in Washington, D.C., but also in U.S. Attorney's offices, the 93 U.S. Attorney's offices around the country. Right here, 2 of them in Wisconsin, the Eastern District of Wisconsin, which has an office in Milwaukee, and also in Green Bay, and then also the Western District of Wisconsin, which has an office principally in Madison, responsible for enforcing the federal law in our local districts based upon directives and encouragement and instruction given to the U.S. attorneys by the Attorney General and right now by the acting people who are in charge at Main Justice. Let's talk about something that's happened just recently. This coming out from the Chief of Staff at the department named Chad Mizell. Justice Department has ordered an immediate halt to all new civil rights cases or investigations. Yes, you heard that right. All new civil rights cases or investigations. And also signaled along the way in that same missive, that same directive, that it might well back out of some Biden-era agreements with police departments to do what? To remedy some engagement that they've had with discrimination or violence. And all that comes to us from 2 internal memorandums sent through the Department of Justice in the wake of Donald Trump taking the White House and beginning to install the Trump employees there. The first of those 2 short memos from the Department of Justice ordered a litigation freeze at the Civil Rights Division. My former boss, Eric Holder, often spoke about the Civil Rights Division as providing the heart and the soul of the department. It's how you can measure the integrity of the department and the people responsible for it. And the directive in particular is that freeze applies to the initiation of any new cases in the Civil Rights Division. It also barred lawyers in the division from working and from filing motions to intervene, agreed upon so-called remands, cases are going from one court to another, amicus briefs, which of course, as you know, are friend of the court briefs, statements of interest, all these kinds of things that would articulate the positions of the present administration inside pending litigation, all of that suspended in the midst of continuing litigation until and if there is approval that's received by senior Trump appointments. And it is plainly the clearest sign yet that the Trump administration is taking over the department and tending to move swiftly, as it is plainly in many, many other areas of government these days. In addition to this significant halting of new cases and new case litigation movements, perhaps even more significant, there's a second memo that orders a similar freeze on department activity across the board, Civil Rights Division, involving so-called consent decrees. Now, we've talked a lot about these things in the past. Those are those agreements that are hashed out, typically between local governments and others, to address some police practices that have run afoul of the commitment of police officers to serve and provide support to all of us. Could be based upon identified practices that are race-based, based upon ethnicity or gender, sexual orientation, disabilities of the people that the police are intended to serve. We've seen those in a lot of different cities around the nation. And indeed, during the Biden administration, an awful lot of focus on putting those consent decrees in place. They have different kinds of iterations, different kinds of formats. But the whole idea is to try to establish a new format, a new set of policies and practices inside a particular police department to address the woes and the errors and the faults of the past. The new administration may wish to reconsider those settlements and consent decrees negotiated and approved during the prior administration. That's what the Chief of Staff wrote. The order could, of course, scuttle agreements reached recently with the Louisville, Kentucky Police Department. You recall that. That was in the wake of the killing of Breonna Taylor. There was that Minneapolis decree in the aftermath, of course, of the George Floyd murder as well. Neither has received final approval by a federal judge. That's a part of the process, too. And there are plainly other voluntary agreements, consent agreements. These are agreements between the police and the Department of Justice that could likewise be jeopardized by this decision to stop all of them from going ahead. The president has nominated Harmeet Dillon a lawyer from California, to serve as the chief of the Civil Rights Division. Ms. Dillon, who will be responsible, again, for things like these police cases, all kinds of civil rights cases in the areas of housing and voting and academics and access to the basic trappings of our lives. All of that under the rubric and the supervision of Ms. Dillon coming up when she is approved by the Senate and takes her position. She, in the past, not only a major figure in the state Republican Party in California, which does not disqualify her by any means, but also supporting Donald Trump's false claims of voter fraud. Voter fraud. That's the incoming civil rights chief in our United States Department of Justice. We know as well that there have also been some significant movements of attorneys inside the Department of Justice. Let's talk about one version of that. Many of the attorneys who previously worked inside the Civil Rights Division told, again, these are civil servants. These are not political appointees, told that they're now going to be moved to different units of the Department of Justice, no longer working in these civil rights areas. Many of them directed to become a part of a new entity, a new division, a new initiative that's going to focus on sanctuary cities and determining whether those sanctuary cities, you know what they are, you know what this process is all about, whether they themselves are in violation of the president's policies and practices when it comes to these kind of initiatives. And so all of that coming up here on Amicus Law Review as we talk more about employment inside the Department of Justice here on the broadcast stations of Civic Media. This is Amicus Law Review. My name's Jim Santel, reviewing recent events inside the Department of Justice, even at this time of transition, talking about these major decisions to suspend the work of one of the most critically important divisions inside the Department of Justice, the Civil Rights Division. That, again, has a rich history in terms of supporting the civil rights of Americans in all states of our union, and then talking as well about ways in which the Civil Rights Division will perhaps forever be changed at least under this administration, moving attorneys who are experienced, who know what they're doing, who've handled these kinds of cases in the area of voting rights and housing and education and healthcare, all kinds of things, moving them out of their areas of expertise into other units. Now, they still have the skills to be litigation lawyers. They're superb. They are civil servants. They are not political employees, but moved at the direction, presumably, of the present leadership, such as it is at the Department of Justice, and probably by the United States White House as well. Directives from the White House to the U.S. Department of Justice, some of them being moved into a new initiative to determine whether or not so-called sanctuary cities, places where people who are in immigration status can find sanctuary and protection, whether those kinds of actions by cities adopted by city councils and by mayors, whether those should be the subject of investigations and prosecutions. That's where some of these attorneys have now been moved, I'm certain, much to their chagrin and to their dismay. We know as well that there's another thing that's happened inside the Department of Justice, and that is with respect to something called the Honors Program. It is accessible on the Department of Justice website. This is a mechanism through which the best attorneys, typically young attorneys coming out of law school, coming out of clerkships, were interested in doing the work of the Department of Justice, civil litigation, criminal litigation, mainly at the Department of Justice, but sometimes in the U.S. attorneys' offices around the country. A mechanism for identifying them, bringing them into the fold, training them in a way that will ensure that the future of the Department of Justice is secure. That honors program almost completely decimated in recent days. Notices sent out to the incoming honors program attorneys at the Department of Justice that the offers previously made to them to be placed in various positions, not just in civil rights, but in other areas, in the civil division, the tax division, the antitrust division, the environment and natural resources division, the criminal division, the national security division, all kinds of divisions, litigating divisions inside the Department of Justice. Their offers, the best and the brightest people coming in, all of those rescinded by this present administration. We'll see what happens with the honors program in the future if it is resurrected in some way, but that too, a way of changing dramatically not just the composition, but also the very texture, the very way in which the Department of Justice operates on a regular basis. And then there's this. Then there is also this news coming out of the Washington, D.C. groups just this past week, and coming out from the White House in particular and the Department of Justice. President Donald Trump's administration has begun to fire those lawyers who prosecuted him. Perhaps not surprisingly, but nonetheless, it is still stunning to see. Officials were fired after acting Attorney General, his name is James McHenry, he is there until Pam Bondi is confirmed and takes her oath of office, concluded that these particular attorneys who brought these cases, the two federal cases against Donald Trump, they once again are the insurrection case. That was a case in front of Tanya Chutkan. You remember that well. That dismissed recently by the prior administration, by Jack Smith before he left. And also that other case pending in South Florida. That was the documents case, the classified documents case pending in front of Eileen Cannon. The attorneys involved in this mass firing were the attorneys who were prosecuting the cases against the principal defendant in both of those, his name, Donald Trump. The officials, again, were fired after the acting attorney general concluded, quote, that they could not be trusted to faithfully implement the president's agenda because of their significant role in prosecuting the president. That's what the present attorney general said in firing these attorneys who were responsible as civil servants for bringing the law to courts and bringing these presentations to grand juries before judges, ultimately doing their jobs. McHenry cited Trump's power as the chief executive under the Constitution to justify the firings. The lawyers again worked with special counsel Jack Smith during his years-long term. He led, once again, those two principal criminal federal cases. News of these firings came the same day that Ed Martin, who's the U.S. attorney in Washington, D.C., and also a Trump appointee, opened an internal investigation, an internal review into the use of the felony obstruction charge in prosecutions of people accused of taking part in the January 6th riot, the insurrection at the United States Capitol. You may recall this. We talked about this long ago on this very broadcast. This is the case involving Fisher. He was one of the thousands of people charged with violations of federal law. And the question was whether or not the particular statute under which he was prosecuted could indeed be applied to people under his circumstances. The court, by a split court, determined in the end that the invocation of this particular statute was not rational, not based, not at all a thing upon which there was unanimity inside the Supreme Court. The United States attorney now investigating whether or not those who used that statute, they themselves should be investigated, and if some action should be taken against them. We know as well that all of this happening, as I mentioned already, that some 20 senior career Justice Department attorneys, including a fellow named Bradley Weinsheimer, the top ethics official, and the former chief of the public corruption section, his name is Corey Admonson, again, moved from their roles as a part of this attempt to change dramatically the Department of Justice, the way that it works, the people who inhabit that place. The workforce shakeup there is not unanticipated. It certainly comes with anticipation in some areas that all U.S. attorneys, again, who are not civil servants. When I was U.S. attorney, I understood well that becoming a presidentially appointed U.S. attorney, you are no longer protected by the civil service. That, yes, indeed, we anticipate that U.S. attorneys and others in top positions at the Department of Justice who are these political appointees will, in fact, be changed. The concern here is the movement of the transfer of these longtime civil servants who know what they're doing, who've got the expertise in these areas. stopping them from doing the work that they have done so well under all kinds of administrations, not just the Biden administration, but frankly, under prior administrations of both Republicans and Democrats, stopping them from doing that. When Pam Bondi comes in, when Kash Patel comes in as the chief of the FBI, presumably they will have some significant power now in assigning people inside the Department of Justice, making some political appointments, again, through the presidency, but also making significant decisions about the emphasis of the Department of Justice. And plainly, one of the messages coming out of these recent firings, these recent movements of attorneys inside the Department of Justice, is we're about to see a Department of Justice of the sort that we have not seen in a very long time, if ever. We'll continue to monitor all of this, of course. We'll also continue to monitor something else that reflects upon the change in approach by the Department of Justice. And yes, indeed, this impacts directly those 93 U.S. attorneys around our nation. A directive issued just recently by an individual whose name we know well. His name is Emile Beauvais. He sat next to the president as late as just 3 weeks ago when the president was finally being sentenced in that Manhattan courtroom for his 34 violations of state law in Manhattan, violations of those false statements, those fraudulent representation counts. Emile Beauvais among the defense team for Donald Trump, his personal attorney, now taking his role for a while as the acting deputy attorney general. Ultimately, he'll become another high-ranking official inside the Department of Justice. He's a former member of the president's criminal defense team, and he is now issuing also memorandums inside the Department of Justice. This one sending messages to all United States attorneys. It's a 3-page memorandum. It was issued the week before last. It's intended to provide guidance, which memorandums of this sort can and indeed often do. Not unusual for any Department of Justice, any deputy attorney general, any attorney general to issue directives generally to U.S. attorneys and to others inside the Department of Justice about emphasis and about direction, without directing particular prosecutions, without telling particular U.S. attorneys who to indict and who not to indict. In this 3-page memorandum, guidance to all department employees, including especially U.S. attorneys, interim leaders, continuing U.S. attorneys around the country to do what? To investigate and, yes, indeed, as appropriate, prosecute criminally law enforcement officials who decline to enforce the immigration policies and practices announced by the White House. The memo commands state and local officials to cooperate with the department under the Constitution's Supremacy Clause. We know what that's all about, the supremacy of federal law over state law, or face criminal prosecution or perhaps civil penalties if they fail to comply. Of course, all of this as a part of the president's and, yes, indeed, the Department of Justice's incredible focus, perhaps beyond any other focus on immigration issues. The law, the criminal law, the federal law here that is invoked in this memorandum, according to Emile Beauvais, prohibits state and local actors from resisting, obstructing, and otherwise failing to comply with lawful immigration-related commands. That's what Emile Beauvais wrote in this policy. And again, a lot of pushback on this policy because, of course, it's the federal government that's principally responsible for the enforcement of immigration law. And that too is where? That is in the Constitution of the United States of America. We have had some pushback already. You've got a spokesman for the Attorney General. His name is Phil Weiser in Colorado. He says, as far as we know, no state or local officials are obstructing immigration enforcement. He said the federal government, and he's right about this, not local law enforcement, is responsible for enforcing federal immigration laws. Governor Katie Hobbs of Arizona, she said the memo was a distraction. She added, I refuse to let political games get in the way of ensuring the safety and the security of every Arizonan. All of those kinds of things coming out of Washington, but also coming out of state and local officials responding to this. And again, as a part of the general approach of law enforcement, local, state, and federal, the great concern, aside from the threats of criminal prosecution and investigation, if you do not comply, if you do not fall in line with the White House's policies on immigration, is the wedge that this will send in between federal and state and local law enforcement. It is a part of the practice under all previous administrations that local law enforcement gets together and decides how to prosecute, how to investigate cases. That's good law enforcement task forces. Groups of people coming together from different jurisdictions to discuss the ways in which they can keep the state of Wisconsin, the state of New York, the United States of America safe and secure, using limited resources, coming together, quite literally sitting around a table and not just negotiating, but cooperating and figuring out ways with limited resources, but with focuses upon our safety and security. How do you do that best? Well, when you're sitting around a table where one of the participants, namely the U.S. attorney, has been directed to investigate or prosecute somebody who is on the left or right side of that U.S. attorney because they're not in compliance with what the president wants in terms of the federal enforcement of law, that sends a wedge. And that chills all law enforcement. Offer that the memorandum, presumably given the imprimatur by the White House, but issued by Emile Beauvais, who will continue to be a major player in the Department of Justice even after all the leadership is in place. This memorandum, again, changes the ways in which local and state law enforcement interact with federal law enforcement, not to the good. All of that happening inside the Department of Justice these days. And yet a footnote coming out just recently to all of this, having to do with the mayor of the city of New York. His name, of course, is Eric Adams. As Amicus Law Review continues, we'll talk about something else that's going inside the Department of Justice as to that criminal case against him. Stay with us here on the broadcast stations of Civic Media.
You're listening to Civic Media. Find the latest news, information, and archives of all your favorite shows on the Civic Media website, civicmedia.us.
This is Amicus Law Review. My name is Jim Santel, your host for the remaining moments of this first hour, and yes, the second hour, in which we're also going to be talking a lot about the United States Supreme Court, some cases pending in our federal courts around the nation. But returning here to the things that are going on inside your Department of Justice right now, in addition to all of the significant personnel moves, the firing of prosecutors, the movement of longstanding civil rights attorneys, the changes in the Civil Rights Division, this directive from the Principal Associate Deputy Attorney General to investigate and prosecute local and state law enforcement if they don't comply with the directives of the White House. All of that going on. Well, there are also being some decisions made having to do with particular cases that are pending out there coming over from the Biden administration, things initiated during that term. You will recall well this prosecution against the mayor of the city of New York. His name is Eric Adams. He was indicted in September, you will recall, on charges including bribery and fraud and soliciting illegal foreign campaign contributions. That, of course, in the wake of an investigation that began way back in 2021, he has pled guilty. We will do as we always do. We will affirm that he is innocent until proven guilty. And indeed, Mayor Adams has maintained his innocence and contended that he is being prosecuted because he criticized the Biden administration's immigration policies, even as New York was receiving a significant influx of migrants. We know that from the news as well. Federal prosecutors have consistently rebuffed this and said, no, this is based upon the facts. This is based upon the facts presented to a grand jury that decided in the end that there is probable cause to believe that the mayor of the city of New York has engaged in all of that. In recent weeks, of course, you also know from the news that Eric Adams has certainly curried some favor with Donald Trump. He's met with the president-elect near Mar-a-Lago. He attended the inauguration. Nothing wrong with any of that. And has said from now on he will share any criticisms of the president in private. Nothing wrong with any of that, but it gives rise to concerns about whether or not the decisions that may be moving forward on Eric Adams' prosecution, the criminal case against him, might be animated once again by the President of the United States of America. According to several people, the mayor and the president have been in direct communication for weeks. They speak on the phone. After a meeting in West Palm Beach not too long ago, they did not discuss a pardon, apparently by all accounts, but Donald Trump did speak about a weaponized Justice Department. And he has described Eric Adams having been mistreated as he himself was, according to the president, as a result of the weaponization of the Justice Department. The U.S. attorney there in the Southern District of New York, her name is Danielle Sassoon. She's a veteran prosecutor. She was selected by the Trump administration. She, again, is responsible for overseeing all of this. And the news, of course, of just this past week that is not yet definitive, not yet certain, but news coming out of reliable sources of the Department of Justice that some senior Justice Department officials in this new administration are holding discussions with federal prosecutors in Manhattan, including the U.S. attorney there, about the possibility of dropping that corruption case against Mayor Eric Adams. It's according to a number of people with knowledge of this matter. The reporting, a lot of it coming out from the New York Times, indicates that they have spoken to Eric Adams' defense team since Donald Trump took office. The defense team led by a fellow named Alex Spiro, who is also the personal lawyer for a fellow named Elon Musk. You've heard a lot about him in recent years. Elon Musk, of course, the richest man on the face of the planet, one of the president's closest advisors. The attorney for Elon Musk is also on the defense team for Eric Adams. Now, apparently, the subject of some discussions about whether or not the criminal case against him should be dropped in the future. That's significant, coming out of, again, without certainty, coming out of reliable sources in the Department of Justice, perhaps bringing an end to that prosecution against the mayor of the city of New York. We know as well that just in recent days, federal prosecutors have also dropped the last remaining efforts to prosecute Donald Trump's two remaining co-defendants in that classified documents case brought by, yes, Jack Smith, who's the special counsel. Single-page filing. Prosecutors have asked a federal appeals court, that's the 11th Circuit in Atlanta, to dismiss the remaining portions, the vestiges of this case, this appeal that had been filed before Donald Trump took office, that was seeking to reinstate criminal charges against these two men. Their names, you may recall, are Walt Nauta and Carlos de Oliveira. The two of them had been added on to the indictment by Jack Smith long before the election, long before any of these other things happened, based upon charges that they'd engaged in obstruction of justice in the government's repeated efforts to retrieve these documents, to find out where they are, to get them back. All of this a part of that prosecution, dismissed by the federal district court judge, ultimately resulting in the United States Department of Justice dismissing the case entirely as to Donald Trump. And now under the new administration, as to these two remaining defendants, these co-defendants in that case, the prosecutor is moving the 11th Circuit, which is the last portion of this case, to dismiss that case against those co-defendants, Walt Nauta and Carlos de Oliveira. It is significant, of course, because this will bring to an end this long and storied history of these cases against Donald Trump and others in his ambit. We know that at least one of these, Walt Nauta, continues to be a close associate of the president, apparently also involved in employment at the White House to this time. It appears that the 11th Circuit will almost certainly grant that motion to dismiss this case against him, once again bringing this case, like all others, to an end. We know that because of past history, and we know about the processes by which these matters go forward in our federal courts. More about federal courts, including the United States Supreme Court, in our second hour as Amicus, a law review, continues. This is Amicus, a law review. This is our weekly weekend review of all things law-related, justice-related, rule of law-related. A lot of focus upon the institutions of government, including in this edition of Amicus, a law review, things related to the Department of Justice. Big changes internally and externally as the Trump appointees and Trump non-appointees, civil servants, change a lot inside the Department of Justice, at Main Justice there on 9th and Constitution in Washington, D.C., but also around the nation as the president, as is his obligation under the Constitution, nominates, again with the appointment of the advice and consent of the Senate, the appointment of U.S. attorneys nationwide. That all happening in this transition period. Right down the street from the Department of Justice is the United States Supreme Court. We turn our attention now in this second hour of Amicus Law Review to that major institution in Washington, D.C. My name is Jim Santel, your host for this second hour of Amicus Law Review. We have talked a lot on this broadcast about the United States Supreme Court because it plays a major role, as you all well know, in who we are in America, making some major decisions about all kinds of things: privacy rights, education rights, environmental issues, agriculture, commerce, labor, you name it, the Supreme Court is involved in the issue. One of the issues, of course, which I encourage listeners to think about is whether or not the Supreme Court now making many of these decisions, and yes, indeed, they come up through litigation. They come in challenges in the courtrooms around our country through the federal and appellate courts, ultimately getting to the Supreme Court. Question whether or not the policy focus on all of these major issues has now been taken over by the United States Supreme Court. Why? Because the other branch just across the parking lot there on Capitol Hill, it's the Congress. Those are the people inside that wonderfully important building, the cornerstone of our entire democracy, the Capitol, the House of Representatives, the United States Senate. Whether those people, the people we send there to decide policy for us, to make these critically important and, yes, difficult and challenging decisions, whether they're doing their jobs. And more as issues related to all kinds of things. Yes, indeed, involving immigration, indeed involving the status of a president to uphold or not uphold the federal decisions of the Congress when it comes to spending and federal programs, all of those kinds of things ending up in our courts, including ultimately the Supreme Court, because more and more, and this has been the history, of course, in recent times, our Congress cannot and apparently does not decide these major issues. I would offer to you that as you read the Federalist Papers, as you think about the Constitution of our nation, and even the Constitution of it with a small c, as we approach in a couple of years here, the 250th anniversary of our nation as we know it, whether or not our nation would be recognized by our founding fathers for the incredible amount of power that now exists inside the United States Supreme Court, and of course, at the other end of Pennsylvania Avenue, and that is in the White House. We've talked a lot about that as well. In between those two buildings, of course, is the U.S. Department of Justice. That's a part of the executive branch. It is not an independent branch of government. It is inside the Department. The Department of Justice is inside the executive branch, and it too, again, exercising on behalf of an extremely powerful president an awful lot of authority. The question we raise as students of civics in America in 2025 here in Wisconsin and throughout our nation is, where is our Congress? Now, plainly, they get a lot of attention. They get a lot of attention in terms of recent days, confirming nominees. Yes, that's right. Or not confirming them. Doing oversight of various issues. The question is, when it comes to these big ticket items like policy issues having to do with immigration and commerce and labor, yes, and agriculture, and all kinds of other things out there, civil rights, this Congress of recent times, this is the 119th Congress, has certainly not been as active in terms of major issues, and instead those falling to a president and presidents, plural, who issue executive orders in absence of congressional action, and yes, more and more to the Supreme Court that decides cases when the Congress is not deciding those as our representatives. So let's talk, as we often do, about the inventory right now before the Supreme Court. Right now, 65 cases pending as of this first weekend in February. 65 cases in which the United States Supreme Court has said, we'll take those cases, where they've granted what's called a writ of certiorari. We've talked about that a lot on this broadcast. That's the order, the writ. 4 of 9 members of the Supreme Court have got to say yes, indeed. Let's take a look at that lower court case. Let's take a look at that case coming out of a Supreme Court of a state in America. Of that 65, here are the big ticket circuits. The Fifth Circuit, that's Texas and Louisiana and Alabama. Lots of focus on the Fifth Circuit these days. Undeniably the most conservative district in our nation. 14 of the 65 cases coming out of the Fifth Circuit, not surprisingly. Close second, Ninth Circuit, huge geographically, very different politically, to use the small p sense of that word. 5 cases coming out of the Ninth Circuit, 5 cases coming out of the Second Circuit. That's basically New York and adjacent states as well. Lots of population there as well. 7 cases coming out of the Fourth Circuit. 4 coming out of the Sixth Circuit, 4 out of the 10th Circuit, 2 coming out of our own circuit, the 7th Circuit. All of those comprising the 65-case docket now in front of our United States Supreme Court. And as we have talked about ever since October 1 of 2024, that's the first day, the first Monday in the new term of the Supreme Court entertaining oral argument, these opportunities for the parties to come forward through their attorneys, through their lawyers, their representatives, and argue to the court orally, vocally, publicly, in support of their positions. We've seen, of course, the sketches of those because cameras are not allowed in the federal courts. But we've also heard from the justices as they have sparred with the attorneys about the merits and demerits of the issues in front of them. And indeed, just in recent weeks, ever since Donald Trump has been the president, while much of our focus has, yes, been on the Department of Justice, and yes, even more so on all of these actions being undertaken with dizzying flurry coming out of the White House, the Supreme Court has also been busy. Supreme Court entertaining arguments on January 21 and January 22nd, 4 cases just in recent weeks that are important. We're going to talk about one of those in particular, but let me tell you about what the cases are, again, as a part of our continuing inventory. A case called FDA, Food and Drug Administration versus R.J. Reynolds. That was decided the day after the inauguration on January 21st. It involves whether a company, sounds pretty wonky, very legal, a company may petition a court in a circuit outside of the company's primary market, that is, outside of it, places where it does principal business. If it can petition a court outside that company's primary market, another circuit, if another company located within that court's jurisdiction signs on to the petition. That's a lot there, and it's the kinds of things that lawyers love to discuss. The question is whether or not a manufacturer may file a petition for review in a circuit court where it neither resides nor has the principal place of business, having to do with jurisdiction and the capacity of particular courts to decide cases. That's FDA versus R.J. Reynolds. There's another case named McLaughlin Chiropractic Associates versus McKesson. It concerns whether a thing called the Hobbs Act requires a U.S. district court to accept the Federal Communications legitimate interpretation of something called the Telephone Consumer Protection Act, whether the Hobbs Act required the district court in this particular case to accept the FCC's legal interpretation of this law. And what does that sound like? That sounds like, yes, once again, the question of whether or not courts should defer to the legitimate, the appropriate, the experience-based views of a federal agency. How many times have we talked about that issue? How often has that percolated up in the annals of not just this broadcast, but of many people across the country who bemoan the fact that we have now gotten rid of 40 years of tradition when it comes to judges deferring to expertise, deferring to intelligence, deferring to people who know what they're doing. This is another one of those cases. Whether or not a trial judge should look at the FCC and say, you know what, your interpretation of this Telephone Consumer Protection Act makes sense. We should follow it absent it being totally ridiculous. The question, once again, whether or not the Hobbs Act requires that district court to follow what the lower court what the agency has decided when it comes to interpretation. The issue now being applied on a regular basis, and judges more and more feeling free in the wake of the drop kicking, the abandonment of what you recall as the Chevron deference. Courts more and more deciding on their own because, according to the Chief Justice, they know best. They know best how these laws should be interpreted, as opposed to the experience-based and justice-based decisions of these agencies. Then there's another case. It was decided, or argued rather, on January 22nd. It's called Cunningham versus Cornell University. It concerns whether Cornell University, in its Retirement Plan Oversight Committee, violated the Employee Retirement Income Security Act. You know that as ERISA, as claimed by one of the employees there, whether a plaintiff can state a claim by alleging that a plan fiduciary engaged in a transaction constituting a furnishing of goods and services. Lots of wonky stuff involved in that as well. Lots of things involving language under Section 1106 of Title 29 under, that's right, ERISA. It is nonetheless a big issue having to do with labor issues and ERISA in America. That was argued on the 22nd of January. And again, also on the same day, a major case having to do with law enforcement. A case called Barnes versus Felix concerns whether the moment of threat doctrine, keep that in mind, the moment of threat doctrine should be applied to Fourth Amendment excessive force claims. Questions whether or not courts should apply this moment of threat doctrine when evaluating an excessive force claim under the 14th Amendment. The moment of threat doctrine in law enforcement refers to an inquiry that examines whether officers were in danger of their lives, in danger of their security, at the very moment of the threat that resulted in the officer's use of deadly force. Again, lots to unpack there. Or should that doctrine be abandoned in favor of a more broadly stated analysis of all the facts leading up to and surrounding that use of deadly force? Analysis exclusively focuses on the moment just before the alleged excessive force was used. And so, on the 22nd of January, our Supreme Court entertained argument on exactly that issue. As Amicus Law Review comes back, I'll tell you what the justices seem to be inclined to do when it comes to these excessive force lawsuits and this interesting moment of threat doctrine, which is now before our United States Supreme Court. That as our broadcast continues. This is Amicus Law Review. My name is Jim Santel. I am your host for these remaining minutes, this remaining hour of our broadcast here on the stations of Civic Media, talking necessarily, as we need to do to understand what our government is doing, what our Supreme Court is doing routinely, talking about the recent cases in front of the United States Supreme Court, some of them the kinds of things that lawyers love to talk about, in the weeds, interpreting things like the Hobbs Act and, yes, other issues like ERISA. Nonetheless, very important for all kinds of people in America. You don't always need to understand the ins and outs of all these things, but it underscores the breadth of the kinds of things that our Supreme Court is taking on in right now these 65 cases pending in front of it, including this issue having to do with the issue of moment of threat, a doctrine, again, that I suspect that many of us have not thought about a lot. All of this started in this particular case on an April afternoon, way back in 2016, when Ashtian Barnes, who's 24 years old, was driving on a highway outside of Houston, Texas, in a car that his girlfriend had rented. He was on his way to pick up her daughter from daycare. That's the premise for the case as it plays out. Although Ashtian Barnes did not know it, The car's license plate that his girlfriend had rented was linked to some unpaid tolls that had been incurred by another driver of that same vehicle. So what happens is there's an officer, his name is Roberto Felix Jr. of the Harris County Constable's Office, pulls the car over based upon those unpaid tolls that are attached to this particular car. Again, Mr. Barnes knows nothing about this because plainly the circumstances under which it's rented, he is driving the car. Barnes could not immediately locate his license once Roberto Felix approaches him, and he could also not locate the car's registration. And so the officer asks him to step outside of the car. And instead, Mr. Barnes, Ashian Barnes, began to pull away. That's his action. He begins to pull away and not do what the officer directed him to do. Probably would have resulted in a very different result had he followed those directions and explained what is going on here. Instead, Ashian Barnes began to pull away with the car door still open. And here's when the tragedy gets even worse. This is human tragedy of the highest nature, undeniably. Officer Roberto Felix draws his gun. He jumps onto the moving car's door sill and twice shoots Ashian Barnes. And all this is recorded on the dash cam footage. The mother of Ashian Barnes, her name is Janice Hughes Barnes, sued. And she says that the officer's use of force was unreasonable and violates the Fourth Amendment to the Constitution. This is the mother of the young man who was involved in this horrific incident. He is killed during the course of this horrific event. A unanimous 3-judge panel of the U.S. Court of Appeals for the Fifth Circuit, again, that Fifth Circuit, ruled last year in favor of the officer on what it said was a narrow question. Patrick Higginbotham says this. He says, we may only ask under this particular rubric, under this very narrow moment of threat doctrine, whether Officer Felix was in danger at the moment of the threat that caused him to use the deadly force against Barnes. That's what Patrick Higginbotham, one of the judges on the panel in the Fifth Circuit, wrote. He added a concurring opinion, however, and this is significant because it gets to the Supreme Court on this basis. He said, had he been allowed to consider all the circumstances surrounding the stop, he could have ruled the other way and gone beyond this moment of threat doctrine to permit a trier of fact to assess everything. The judge instead said, given the rapid sequence of events and Officer Felix's role in drawing his weapon and jumping on the running board, the totality of the circumstances merits finding that Officer Felix violated Barnes' Fourth Amendment right to be free from excessive force. But under the rubric, this particular rubric as to police shootings, the moment of threat doctrine required to go in the opposite direction. At this recent argument, the case is called Barnes versus Felix, some justices expressed concerns about second-guessing the police officer's split-second judgments. That is always a legitimate concern. Brett Kavanaugh said an officer does not get the time we've spent here today to make that decision. And indeed, officers are required, as we all know, to make these split-second decisions, sometimes catastrophic in nature. But most of the justices on the Supreme Court seemed inclined to allow the court to consider more than the seconds before the shooting, adopting what Judge Higginbotham encouraged them to do, a broader understanding of the law. Sam Alito said this, would you be satisfied with a narrow holding that is wrong for a court to look just at the moment of the threat? The lawyer said he would, and he said, though he added it would be helpful if the court makes clear that means that you can look at the jump in addition to the shoot. A lawyer for Officer Felix said the court should narrow its focus to the moment he used force, and that lawyer arguing he was clinging to the side of a fleeing suspect's car, and Felix reasonably believed that his life was in imminent danger. That conclusion, the lawyer for Officer Felix said, should end the case. In rebuttal, again, the lawyer on the other side said you have to look at the whole picture, and here that's more than just 2 seconds. The case arose, again, from this commonplace occurrence, a routine traffic stop in America, again, ending in the death of an unarmed black man in this case. The questions for the justices now, how closely should courts consider and confine this analysis to the moment of truth rather than the larger context? It appeared The Supreme Court seemed ready to reject that limit on these excessive force Fourth Amendment suits. There was something of a consensus that theory was now too narrowly focused in the seconds preceding this shooting. And indeed, Neil Gorsuch says, everybody agrees it's wrong. What's the harm of saying that? And the question now, which we'll wait for in June, maybe May, maybe June, maybe July, is what is it that this standard, what the standard, how is it going to look like? What is the Supreme Court going to tell us now is the standard? If it's not the moment of threat, what is the more expansive nature of the analysis that should, in fact, be applied in these kinds of minute-type decisions, these instances where tragedy happens when we have confrontations between law enforcement officers and citizens in America? That case, once again, going to tell us much about that, Barnes versus Felix, as the Supreme Court decides that case and many others on its 65 docket caseload in May and June. More about the Supreme Court as Amicus, a law review, continues. This is Amicus, a law review. My name's Jim Santel, your host for this second hour of our weekend broadcast on law, and in particular the United States Supreme Court. We know that in addition to those oral arguments that have followed the inauguration of our president on January 21 and January 22nd, the Supreme Court has also got more oral arguments scheduled in many other cases coming up in February and March. We know that there are 4 oral arguments between February 24th, 25th, and 26th. 4 more oral arguments between March 3rd and 5th. Lots of things going on in the Supreme Court. You can listen in on those oral arguments as they happen, and you can also pull up the recorded oral arguments for your review, for your assessment. You can hear the justices themselves talk about these cases. You can hear the things that I quote to you in this broadcast as they come out of the mouths of the justices, including Neil Gorsuch and including Sam Alito and others on the bench. All of that, again, going to be a part of our continuing analysis of our Supreme Court. Along the way, from time to time, as you know well, the Supreme Court also does other things. It decides to take or not take certain cases and thereby determining whether or not the laws that are challenged, the actions that are challenged, continue to stand. If the Supreme Court takes a case, it may well signal that they're going to return with decisions that may reverse a lower court. It may reverse an action by the executive branch or another portion of government. But if the Supreme Court decides not to take a case or decides to do something without providing reasons, that also has an impact upon the way that we understand the law in America. So let's talk about something else that sounds very wonky and very lawyerish, and it is indeed a thing called the Corporate Transparency Act of 2021. Supreme Court recently, just this past week or so, revived this federal law. What does it do? It requires companies to report information about their owners in an effort to combat things like money laundering, the drug trade, and terrorism. The Supreme Court basically revives this law that's meant to fight money laundering after some lower court actions, which I'll describe now. The court's brief order, no reasons at all, typical when the justices act on these emergency applications. This is sometimes called their shadow docket. Once again, we don't get reasoned opinions as we do in those many cases coming out in May and June, where we've got tomes of things written by the concurring justices and dissenting justices. Here, the ruling without any particular reasons, but nonetheless upholding and reviving a law that is meant to fight money laundering, among other things. The ruling is what's called provisional. It reinstates the law while a challenge to it at the lower courts move forward. critics of the Corporate Transparency Act of 2021, and this is where this all comes about, say it's needlessly burdensome. And by virtue of what it requires under the law, it's a threat to privacy and an unconstitutional federal intrusion, they say, on matters that have been historically regulated by the states. This is a state interest, they say, not the federal government. You're way overreaching here. Congress shouldn't do this. No authority to pass this kind of legislation. The challenge to the law brought by a firearms dealer, a technology company, a dairy, and the Libertarian Party of Mississippi. Also, the National Federation of Independent Businesses, which was the lead plaintiff in the first major challenge to the Affordable Care Act as well. In that case, you may recall the plaintiffs in the challenge to the transparency law argued that the Constitution's Commerce Clause did not authorize Congress to regulate what they said was inaction rather than an economic activity. So a lot of these issues, once again, being revisited in this challenge to the law. The challengers here noting the law covers tens of millions of very small businesses, small entities out there, including homeowners associations and family trusts. They said that complying with the law will collectively cost tens of billions of dollars. We can't suffer that, they said. And in addition, it's way beyond the capacity of Congress to act. And again, consistent with how they've argued before, Supreme Court, they said, should strike this down. At a lower court, the Federal District Court in Texas, a judge named Amos Mazzant, M-A-Z-Z-A-N-T, he blocked the law nationwide, saying that Congress had overstepped its constitutional authority. Though seemingly benign, he said, this federal mandate marks a drastic twofold departure from history. First, he said it represents a federal attempt to monitor companies created under state law, a matter that our federalist system has left almost exclusively to the several states. He's buying into that states' rights theory. And second, he said the CTA, again, the law here, the Corporate Transparency Act, the CTA ends a feature of corporate formation as designed by those various states, again, using that concept. And that concept is anonymity. He said, for good reason, plaintiffs fear this flanking quasi-Orwellian statute and its implications on our dual system of government. The lower court judge, the federal district court judge in Texas, blocking the law, saying it cannot be enforced. A 3-judge panel of the U.S. Court of Appeals, here we come, for the Fifth Circuit temporarily lifted that injunction, observing, and they said, this 3-judge panel, the ownership and operation of a business are economic activities. A reporting requirement for entities engaged in these economic activities falls within a century of the Supreme Court's Commerce Clause jurisprudence. Nothing wrong with this at all. That's the first 3-judge panel. It was divided. And a different 3-judge panel of the Fifth Circuit later reverses course, and it blocks the law while the appeal moves forward. Arguments for the Fifth Circuit are scheduled for late March. Following all of that, it's a lot. Once again, it's a lot to consume. You've got judges there, lower court judges, district court judges, appellate court judges going in opposite directions on this legitimate issue about whether or not Congress, in its economic activity rubric, can in fact pass this kind of legislation, or whether or not it's so burdensome and invades the anonymity, as the lower court judge said, that it is indeed Orwellian in nature and therefore should be stricken down. So what does the Supreme Court do just recently? The Supreme Court basically says the law can continue to be in effect while the lower courts, including the Fifth Circuit, continues to argue about all of this. A major argument coming up again in March about this. But in the meantime, the Corporate Transparency Act, again, blocked by a federal judge. Supreme Court reviving that federal law requiring companies to report this information about their owners to combat money laundering and other things like terrorism and drugs out there. Again, the limited order here, without any reasons, without clear statements, a part of the docket of the Supreme Court when they review these kinds of things on emergency applications, changes the law, right? It changes the way that the law will be applied. Right now, the Corporate Transparency Act is still alive, awaiting further oral argument in the Fifth Circuit, certainly going to be returning to the Supreme Court ultimately one day to decide this contested issue. Reasonable people on both sides saying you can't do this. Supreme Court obviously determining for now that they want to hear more from the lower courts before deciding on what to do here. Also a part of the work and the mission of our Supreme Court. Again, we live in a nation where not only can and do reasonable litigants disagree, but they've got this amazing opportunity to petition to our highest courts, including circuit courts, yes, including the Fifth Circuit and the Ninth Circuit and the Seventh Circuit and the Second Circuit and all the courts around their country. And indeed, they can also seek review, if not obtain review, by the United States Supreme Court. They can ask the court to review the lower court decisions. The Supreme Court plainly does not take all of the appeals sent to it, and therefore does what is called denying that writ of certiorari as to many people who are dissatisfied with lower court judgments. Here, likely the Supreme Court will take this one up, grant a writ of certiorari after the Fifth Circuit is completely done with it. In this instance, telling the lower court, you entertain your oral argument, you go ahead and do this. In the meantime, the law stays in effect for not only Texas, not only the Fifth Circuit, for all the rest of us who are responsible for abiding by the law of the United States of America. We've talked a lot about that in recent days, recent times, when we invoke once again the requirement of our Constitution that says that the President of the United States of America has got to take care that the laws of our nation be faithfully executed. That language being used more and more by federal district court and presumably one day appellate court judges in addressing many of the kinds of things that the Trump administration is doing these days, not only in connection with financial programs, federal funding programs, a judge, again, stopping that from happening, ultimately, maybe the White House rescinding those bans on the expenditure of federal monies for all kinds of programs out there. Still a little bit murky in terms of what the White House has and has not done. Another court, as we know well, a district court in Washington, saying that the approach of the president when it comes to birthright citizenship, that first sentence of the 14th Amendment, that can stand. He says it's undeniably unconstitutional what the president has done. And all of that invoking this notion that the president is required to abide by the law as established by the Congress, as, yes, executed by the executive branch, but nonetheless following the law, taking care that the laws of our nation be faithfully executed. All of that going on inside the rubric, inside the standards of our United States Supreme Court. We know as well that there are other things going on in the federal courts of America. I'm going to talk about more of that right now. We have talked in the past about the role of the Department of Justice in a nonpartisan, apolitical way of charging and, yes, seeking the convictions of people regardless of their partisan views, their political affiliations. We know that under the Biden administration, for example, there was a prosecution of the president's own son on gun charges, on tax charges. Now, as the president's son was convicted and then facing sentencing, we know well that the former president, also pardoned his son. Lots of controversy about that. Lots of controversy about all the pardons issued by Joe Biden and by Donald Trump in recent days. And we've talked about a lot of the merits and demerits of the use of that pardon power. But we know that all of that comes in the wake of a Department of Justice that should be apolitical, that should be premised upon what the facts of cases show and what grand juries and what investigations lead to in terms of charges against individuals. We know that in the prior administration, that a person named Robert Menendez, the New Jersey's former senator, was charged by this process under the Biden administration Department of Justice, by a grand jury convened again by the courts. The grand jury, of course, an entity of the United States court. Robert Menendez charged with violations of federal law. Robert Menendez, a Democrat, a powerful longtime senator, convicted last year on federal bribery and corruption charges. We know that well. We know exactly what this was all about. And the nature of the charges presented in a federal court in Manhattan. The course of that trial, again, indicted 16 months ago while Menendez was serving as the chairman of the Senate Foreign Relations Committee, one of the most powerful perches in Washington, D.C. As a result of all of that prosecution, the prosecution against Menendez, ultimately Menendez found guilty of those federal bribery and corruption charges. And just recently, Robert Menendez, as a part of our process in our federal system, afforded to everyone, every defendant, including Robert Menendez, including Donald Trump, in a different setting, a different court, that court in Manhattan 3 weeks ago. Robert Menendez appearing in a courtroom, a federal courtroom, also in Manhattan, to receive his sentence imposed by Judge Sidney Stein. He's a federal district court judge there in the Southern District of New York for the violations of law for which he was convicted. And that process, again, is something that every defendant in America is exposed to as a part of our routine process of the administration of justice. We can comment about this. We can disagree about these kinds of things. But we all need to embrace the notion that our system is premised upon this kind of process. And as Amicus Law Review continues, we want to tell you about what Sidney Stein, the federal district court judge, said in that sentencing of Robert Menendez, also a part of the rule of law in our nation. And then we'll also talk about another aspect of the rule of law having to do with yet another character in our national history, our national recency, named Rudy Giuliani. All of that as Amicus Law Review continues. This is Amicus Law Review. This is our final segment of this 2-hour program, talking now about 2 cases in which the federal system works. Regardless of how you think about the results of the justice system with respect to Robert Menendez and Rudy Giuliani, appropriate for all of us under our First Amendment to be able to talk about these things in public. That's one of the other joys and delights and honors of our nation, where we can talk and even disagree about these things, but all embracing the notion that there is a process. And that process includes a trial in which you are presumed innocent until a jury finds you guilty, if at all. And then after that, a sentencing that's conducted by a federal district court judge or a state district court judge, a trial court judge, presumably, who has heard the evidence and can impose a just sentence. At the trial of Robert Menendez, you may recall, jurors were told how Menendez secretly drafted a letter on behalf of Egyptian officials who were hoping for millions more in military aid from the United States, shared some sensitive details about U.S. Embassy personnel in Cairo, also attempted to interfere with state and federal criminal prosecutions in New Jersey on behalf of various allies. An extraordinary trial. In the end, the federal district court judge just this past week imposing an 11-year sentence, an 11-year federal sentence upon former Senator Robert Menendez. The judge saying this, he says, "You were successful and powerful." And before announcing the penalty, the judge went on to say, "You stood at the apex of our political system. Somewhere along the way, I don't know where it was," this is the judge speaking, "you lost your way. Working for the public good became working for your good." Your good. That's what Judge Sidney Stein said as a result of this. During the course of the proceeding, former Senator Menendez was there with his sister, both of his children, sitting directly behind him. As the sentencing concluded, of course, he lingered somewhat in the courtroom. He grasped the knees, on one knee on a chair, and as he grasped his children's hand, then he headed out to address a crowd of reporters. And in the public arena, he was not nearly as chastened as he was appearing in front of the judge. When Robert Menendez was speaking directly to the judge as a part of this process, his right of allocution, he described himself as a chastened man who had suffered the ignominy of a guilty verdict and the resignation of a Senate seat. He said, "Every day I'm awake as a punishment. I ask," he said, "you to temper your sort of justice with mercy for a lifetime of duty." And it was after that, of course, the judge imposed this 11-year sentence. Publicly, the senator, after embracing his children in the courtroom, went out into the public and offered a scathing indictment of the justice system and what appeared to be a direct appeal to, yes, President Trump, who has the power to pardon him. The president has given no indication, of course, that he would entertain that pardon for former Senator Menendez. But Menendez said this publicly. He said, let me just say this. He said, this whole process has been nothing but a political witch hunt. He said, President Trump is right. This process is political and it's corrupted to the core. I hope President Trump cleans up the cesspool and restores the integrity of the system. Again, Daniel Sassoon, whose name we heard before earlier in this broadcast, said in a statement that the sentencings of Menendez and two of the co-defendants send a clear message about justice. He said they send a clear message that attempts at any level of government to corrupt the nation's foreign policy and the rule of law will be met with just punishment. Lots and lots of debate in the wake of this, in the midst of this, about what happened to Bob Menendez. At a minimum, they need to embrace the process that resulted in a very strong sentence, 11 years in federal prison for this violation of the public trust, and a process coming to its conclusion or its near conclusion, because again, Robert Menendez is going to appeal this. He has already indicated he's going to appeal this. In the meantime, the court has allowed Menendez to remain free on bond pending that appeal. He also delayed the start of the sentence until early June so that he could attend the trial of his wife, which you may recall is also facing like charges in all of this. Lots of procedural history yet to come. Menendez not yet surrendering that for that term of imprisonment because of his interest in appealing, as he is right to do under our system, to the Second Circuit Court of Appeals. Arguably, one day, perhaps reaching the Supreme Court. Unlikely they would grant certiorari in that case, but all of those avenues in our system open to a defendant now sentenced and exercising his right to appeal that judgment to a higher court. In another court, Rudy Giuliani, the former mayor of New York, grilled for hours in federal court after missing several deadlines and handing over $11 million of his prized possession to those two poll workers who he defamed after the 2020 election. He previously avoided being held in contempt of court, but recently Giuliani settled all of this. He keeps some of his property in settlement of that defamation case, an agreement allowing the former mayor of New York City to keep his apartments and some other valuables that were subject of all of this dispute in return for an undisclosed payment to those two election workers who he defamed after the 2020 election. He reached this settlement with those two Georgia election workers. We may recall that he repeatedly defamed them by saying that they underrode, they compromised the votes in Georgia. The former mayor, as a result of that, found civilly liable for defaming the two of them. He was at risk of losing millions of dollars worth of personal mementos, valuables, real estate that he had gathered over his decades practicing law and then in public office. He had previously been ordered to pay down about $11 million of, yes, that's right, the $148 million judgment he owed the election workers, their names, Ruby Freeman and Shay Moss, a part of the history of this litigation. Good for them in not only enforcing this judgment, ultimately settling it for an undisclosed amount. That is also a part of our system of justice in America. Join us again next weekend as we continue to address things in the courts of America, in the halls of justice in America, here on Amicus Law Review and the broadcast stations of Civic Media. Have a good weekend, everybody.
The national news cycle never stops, but it can be hard to find news about your local community. Civic Media is dedicated to providing quality local and state news coverage across Wisconsin. With the Civic Media app, you can get notifications about local stories that matter to you and your community. Find the free Civic Media app in your phone's app store and choose notifications from the menu to tell us what kind of news you want to hear about.